Okay, so welcome to the exam prep webinar. Now I'm running this as a combined session for the LLBs and the JDs. And perhaps if we could start, if you could type into your chat box if you can hear me okay. Okay, can you hear me? Wonderful. Great. Thanks, Jennifer, Jasmine, Keela. Wonderful. Awesome. Alrighty. Well, I will leave that there. Got the little chat box. Okay, thank you. Awesome. Okay. That's it. Okay, sorry, just setting up a few things there. All right, so what I might do here is I will share the screen so that we have the... Okay, so hopefully you can see the exam there. So what my plan for the webinar is to go through each of these questions. So we've got 4 questions. Now, I just want to be really clear. These are questions from an old exam. So this is not meant to reflect what your exam will look like or the topics that will or won't be covered in your exam. So this is just a colleague here gave me an exam from a number of years ago. I made a few tweaks, but this was basically an exam from a few years ago. And basically I'm going to take you through each of these questions as if we were doing an exam now. Now, before I start that, did anyone have any questions? Anything in particular that you wanted me to focus on? I see Jasmine's asked, can I provide tips to help pass the final? Okay, here we go. So we're getting a few questions in. Jasmine, I might do that at the end rather than start now because I want to make sure I get through this content. All right, so I'll make sure I save a few minutes at the end. Tips for exam. Okay, and then someone's asked, okay. Okay, so we're getting a couple of questions. So I'll just take a couple of minutes to answer questions. If this starts taking over the whole session, then I might put a stop to it at some point and say, let's focus on the sample exam. But I'm happy to take a few questions. Okay, so let's see. So Emma has asked, my question is whether this sample exam's questions is the length we can expect for questions in the final exam. So Emma, this is actually a complicated question. It depends on whether you are a JD or an LLB student. So if you're an LLB student, then this is roughly the sort of length questions that you'll get in the exam. So I'm coordinating the LLB but not the JD. So for the JD, I wrote a question for the exam, but to be honest, it was like 8 weeks ago. I can't remember exactly what the exam looks like. I'm not the coordinator. It's not my place to tell you what the exam questions will or won't involve or to talk about any of that sort of thing. That's solely the coordinator's role. For the LLB though, where I am the coordinator, yeah, you can expect questions roughly this length in the LLB exam. That one's probably a bit long. Yeah, there's quite a, yeah. In the LLB, what we tried to do was have questions around about 3/4 of a page. All right, so there we go. Thanks, Emma. Okay, now I've got a couple of questions on the chat box here. So James asks, what is the effect of sections 194 and 195? It seems a director can vote on an issue for which they have a conflict if the board agrees per 195. Does this not alter the effect of the common law? No, it doesn't really, James. So it's a good question. So 191, 194, 195, you need to think of as a statutory code. They don't change the general law. So just because you're permitted to vote under 194 or 195, that does not mean that you therefore have absolutely no concerns about conflicts of interest. You still might have an issue there. And if I was advising a director, I'd say, if you really want to protect yourself, get approved by the members in the absence of some specific constitutional attenuation clause. Okay. Christine asks about the Bank of New Zealand and Faberry case. Not sure I can do that off the top of my head. So sorry, Christine. If you are an LLB student, then you should post up on the discussion forum. But yeah, so there are some cases I know off the top of my head, but BNZ and Faberry, I'm sorry, I don't. I'd have to go and have a look and then explain it. Okay, so John asks, are there criminal penalties? Oh, supplementary reading link isn't working. Yeah, sorry, John, I will get onto that and I'll make sure that's fixed tonight. Another student reminded me of that. I apologise for that. Criminal penalties link. I'm just writing that down. Thanks, John. Jasmine asks, will you be posting up these sample exam questions on Canvas so we can come back to it? Yes. So Jasmine, the way that you've worded that, I'm assuming you're a JD student. So yes, I posted this under the webinars link on the Canvas page for the Corporations Law JD subject this afternoon. So it's already there. You should be able to see it. And then I posted an announcement for everyone. Okay, then John asks, also, could the main basis of the exam draw on corporate fundraising and solvency and the topics covered in the mid-sem? Now, John, I'm not sure whether you're a JD or an LLB. If you're an LLB student, so just to be really clear for the JD students, because I'm not the coordinator, I can't answer any questions about what is or isn't in the exam. I know I wrote a question. Obviously, I'm not going to tell you what that was about, but I'm not the coordinator. It's not my place to give you any further guidance about what the exam might look like. So I'll just kind of draw a line on those questions. For LLB students, as I posted in an announcement earlier in the semester, anything that was a primary issue, a main issue in the mid-semester, and there's a separate video that goes through the mid-semester exam, won't form the main basis of a question in the final exam. So I can't really be much more specific than that. Okay, and then Dave asks, is fraud on the minority a derivative or personal action? It's a personal action, Dave. So what's happening is the exercise of voting power, either by, or typically by the members in a general meeting, is being used in a way that is oppressing the minority in some way. Now, that's a equitable action, and it's essentially the Court of Equity limiting the scope of the exercise of the decision-making organ, that is the members in a general meeting passing a resolution. So yeah, that's definitely a personal action, not a derivative action, because it's how it affects your particular shares rather than how it's affecting the company. Okay, so John says he's an LLB. Yeah, so John, so thanks for clarifying you're an LLB. So just to go back to your question, so have a look at the announcement that I posted earlier in the semester. So yeah. Okay, then a couple more questions over on the Q&A box. What else have we got here? So Dave asks, reliance and delegation only refer to directors. Does this mean that officers who aren't directors can't use them? That's correct, Dave, yes. So it's a specific defence for directors. And the idea is that the company might be quite large, complicated. There's many different levels of people who are working within it. The directors are sitting there at the top. They set up a framework of accountability and trying to make sure that the right information flows up to the board for its proper consideration. So that task necessarily means they'll have to rely on some others. And then someone else has asked, could I clarify in short what the difference is between the no conflict and no profit rules? That's a really good question. It's a confusing area of company law and really of equity because the rules overlap. And I think the way that you should think about it is they're not really totally separate rules. So they're guiding principles. So focus on what's happened, who your client is, and what they want to try and claim back. What do they want to get out of this situation? So you could have a situation where the directors are operating under an actionable conflict, so a conflict that is a real sensible possibility of conflict between the company's interests and someone else's interests. But they themselves might not get any benefit out of that. So if you think about the wording of section 182 and 183, they talk about improperly using your position or improperly using information to gain a benefit for yourself or someone else, or to harm the company's interests. So a circumstance where you're trying to gain a benefit for someone else, but you yourself are not getting a benefit. So that could be an example of conflict. And in terms of profit, I mean, clearly that's where you're getting some benefit out of the transaction. So don't think of them as being completely separate boxes and it either fits into one box or another box. They overlap. Some of the cases involve both. The key distinction is typically what you're going after. So if you're trying to get an account of profits for breach of fiduciary duty, then you're going over the profit rule, apply the Channon-Zachariah test from Justice Dean. Okay, and then someone's asked, so what I might do here is I'll answer these questions for, say, another 2 or 3 minutes, and then we'll get into this sample exam. Okay, so there's another question here. For related party transactions, 2283 says that parents and children of persons are related parties. Is that exhaustive? What about other relatives? No, it's only lineal descendants. So, for example, one of the things that I posted up for my class, and again, you're anonymous, I'm not sure whether you're LB or JD. So if you're a JD student, this was only if you're in my class. If you're an LB student, then you'd find it in the conflicts class problem question. But I posted up where there's the brother. So a brother, if a director is trying to benefit their brother, that could be a conflict of interest under general law. It could be a contravention of, say, 181, 182, 183, depending on circumstances, but they're not a related party. So you do need to be careful with that. Okay, then Amal has asked, with regard to amending the Constitution, I understand for the expropriation of shares, the test, and Amal, I might just pull you up on that. It's expropriation of rights. So the Gambotto principle isn't limited to just taking away shares. That's the easiest example, but it's actually taking away property rights. So it might be something where you're trying to change the rights attaching to those particular shares, but you're not forcing the person to actually sell their shares. Okay, Gambotto also cites a test to use for amendments not involving expropriation. I'm a little bit confused as to whether to use that case as opposed to other cases. Okay, so the short answer is, Amal, use Gambotto if someone is trying to challenge an amendment to the Constitution. And what Gambotto's case says is, when we're looking at amendments to the Constitution, we don't ask the question, well, did the meeting exercise the power to pass a resolution in good faith in the best interest of the company? And that goes back to the Greenhill case and also the much earlier case of Allen Gold Reefs. Gambotto's case says, well, if you're not affecting anyone's property rights, and I think a way to read that is that basically it's a procedural issue. So, for example, there used to be 21 days notice and we want to change the Constitution to make it 22 days notice. It's not really taking away anyone's property rights. So if it's just a procedural amendment, then Gambotto's case says, well, why do we even need to look at kind of good faith or anything at all? We can just say, have you literally followed the process in the Corporations Act? So have you complied with 136 sub 2? Was it a valid meeting? Was it a valid special resolution? However, if you're exercising the power to vote to change the Constitution to take away someone's property rights, that's a different situation. And so then we need to be saying, well, is it for a proper purpose? And if all you're doing is trying to give yourself as the majority a benefit, that will never be a proper purpose. And the example the High Court raised was if having the member still in the company is harming the company's interests in some way. So there has to be some benefit going back to the company. Even if it is for a proper purpose, you still need to have procedural and substantive fairness. Are you going about it the right way, giving enough information, offering a fair price, etc.? And of course, with Gambotto, there's then a reversal of the onus of proof. So you have a situation where the party who's proposing the constitutional amendment then has the onus to prove that it is for a proper purpose and that it is both substantively and procedurally fair. Okay, so James asks, if oppression comes up in the exam, could it be oppression in a different form to that which it took in the cases? For example, could be conduct of an AGM oppression. What would be the best way to tackle the company policy of not paying dividends? Yeah, really good question, and that's a common point of confusion. So when the High Court talks about oppression in Gambotto's case, they're talking about it in the sense of equities protection for minorities in the sense of fraud on a power, that the majority members who are proposing the resolution by special resolution to change the constitution are abusing their power. It's a fraud on their power. It's oppressing the minority. Cook and Deeks is kind of a good example of that. So 3 out of the 4 directors rip off the company, put on their shareholder hats and say, now we're going to pass shareholders' resolution forgiving what we did as directors, therefore oppressing the minority through their exercise of voting power. Oppression in the statutory sense, so 232 could also include that. So it could be that you're passing a special resolution and the effect of that special resolution is oppressive, unfairly prejudicial or unfairly discriminatory against the minority. But oppression in the statutory sense is much broader. So it can be totally lawful, but we're just looking at the effect of it on the minority shareholders. Okay, so I'm going to make this the last question and then I'm going to go through the sample because we're 15 minutes in. Someone has asked, if a question refers to someone only as CEO, are we to assume that they are also the managing director of the company? I'd say yes if they're on the board. So if it doesn't say that they're on the board of directors, then probably not. Okay, so I might leave the questions just for the moment. If we can go through this and we finish in time, so we've got the webinar for another hour and 15, then I'm happy to take some more general Q&A. But otherwise, I want to get through these questions. All right, now, if you do have any questions on what we're talking about as we go, then by all means, post them up. Okay, so let's have a look at this one. So start with, what's the question actually asking you? You're approached by the board of SS, so that's Smart Solutions, to advise on the company's legal rights in the above circumstances and to advise the board as to any liability that any of the directors of SS may have, any sanctions they may face flowing from their management of the company's business. All right, so let's have a look at what's going on here. So we know who the client is. It's the company and it's also the directors. What are the company's rights, and then what potential liabilities might the directors have? So in terms of assessing that in your answer, you might set that up as 2 broad headings: advising the company, advising the board as to liability as 2 separate headings. Okay, so company relies on replaceable rules. Started off with 2 shareholders, 50% each. Okay, and each of them being directors. Ted's the managing director. So just looking at the question so far, I'm wondering, is this going to be a situation where these 2 directors and shareholders have a falling out and maybe one tries to get rid of the other? So we'll see. And we've looked at cases like that in terms of just and equitable winding up ground in members' remedies, and of course also minority oppression. All right, so Ted does marketing, Jan does computer stuff. Previously prosperous. For each of the last 3 years, issued a small amount of additional shares. Okay, so there's a few other shareholders, not just them after a few years. East Australian working capital. So where you've got circumstances where there's a prolonged problem with working capital, is this going to be an insolvent trading question? Are we going to see more facts? Creditors aren't getting paid, perhaps. In this case, there's just 3 new shareholders, Tom, Sid and Lil. Each of them has 10%. Anytime you get a percentage, then you need to be focused on that. So what does it mean to have 10%? Think about the sort of rights that members have if they have 10% of the votes compared to if they only have 5% or less than 5% in particular. So the ability to convene a meeting, to propose a resolution, to request that information be distributed to members, the capacity with the three of them to block a special resolution is relevant here because the three of them have 30% combined. Each of Ted and Jan now only have 35%. So if we had a combination of 2 out of the 3 and either Ted or Jan, then they'd have a majority, which would mean that they could then remove one of the directors and appoint new directors. All right, company needs more money. Now, it doesn't say that it needs a specific amount, so it's probably not a fundraising question. Serious disagreement develops between Ted and Jan. Okay, here we go. About how to deal with the company's need for new funds. Ted wants debt. Jan wants new equity, saying Ted wants to be the next Bill Gates. Ted threatens to leave the company. All right, so we've got a disagreement there. So then Ted starts to slack off. Jan's discovered that Ted has set up a separate company. And so he's both majority shareholder and director of the separate company. Okay, they found out both at a conference. Oh, I got the dates wrong there. This was quite an old question, and I changed the dates to 2017 and I missed one. That should read 2017. Okay, she discovered Ted was marketing the services of his new company to customers that he previously would have attracted to SS. So that you should be thinking potential director's duties issues there. Is he diverting business opportunities? And you might look at that and say, well, obviously he's diverting business opportunities here. But one thing that you might think about is, well, in what capacity was he at the conference? So was he sent there by SS to represent the interests of SS at the conference, and he's then trying to drum up business for his separate company, which clearly could be a breach of duty, might give rise to an account of profits in the sense that if he's getting some benefit because of his fiduciary capacity, then the Regal Hastings test might be satisfied. On the other hand, maybe he's just at the conference in his own private capacity. He's not under any obligation to do anything for SS. So that would be quite different. So then you'd need, if that were the case, and it's not clear from these facts which it is, so if that were the case, then you'd need to start building an argument about whether he might be misusing confidential information in order to divert business opportunities. Okay, so then what happens after that? So Jan now wants to get rid of Ted as a director and to remove him from the company's share register. All right, so here's where we need to focus on the nature of the company. So it's a proprietary limited company. So if you've got access to your Corporations Act, that would be helpful. Now, I don't want to be skipping through screens, so I might just look at that on my own screen. So in terms of how we get rid of directors. So somewhere in your notes, you need to have a list, minimum number of directors, how do we appoint them, how do we get rid of them? So I'm just going to quickly look at my Corporations Act, section 203. So all the 203s are how we get rid of directors. And one of the things we know there is that for proprietary companies, members can remove them. That's a replaceable rule. 203C, for public companies, members can remove them, and that's not a replaceable rule. So there's nothing in, there's also 203E that says directors of public companies can't be removed by the other directors, but there's nothing in there saying that there's a replaceable rule that directors of a proprietary company can get rid of other directors. So that could be an issue there. So let's see what then happens next. But the problem here is removing from the company share register. That's going to be a problem because, as we know, shares are personal property under 1070 capital A, and you can't use your majority vote to simply take away someone's property rights. So that's that Gambono issue that we were talking about earlier. Alrighty. So let's see what else we've got here. So then in November, Jan was served with a notice of demand at SS on a guarantee made by Nirvana Bank to SBL, so that's Ted's company, which and SPL's failed to make repayments on the loan. Further investigation by Jan shows that Ted has signed a guarantee on behalf of SS in favour of the bank. As SS was a long-standing customer of Nirvana, the bank had accepted the guarantee. Ted asked the bank to make the loan to SPL quickly. All right, so this paragraph here obviously is kind of taking us into indoor management rule territory to statutory assumptions territory. So we need to break it down by stating, okay, well, how could SS be liable here? It seems that Ted has signed on behalf of SS. How did he sign it? So has he tried to sign it as two directors? So has he, for example, forged Jan's signature to bring in the 127 point? And there's clearly a difference here between the indoor management rule and the statutory assumptions. So with the statutory assumptions, we'd need to look at, well, are there dealings? And probably there are, because we know that SS is a long-standing customer. We know that Ted is the managing director. And so in that capacity, he probably would have had dealings with the bank in the past, as a long-standing customer. So the dealings component in 128.1 would be satisfied. And then the question would be whether or not the bank had actual knowledge or suspicion that he lacked the authority to enter into this, which, based on the facts we've got here, is probably not enough. But for the indoor management rule, then we've got the issue of, well, could they be put on inquiry by the nature of the transaction itself? The fact that this is guaranteeing a loan of a competing company. The problem is we don't really know what Ted said to Nirvana Bank. What if he said to Nirvana Bank, oh, well, this SPL, really, it's a new venture that I'm doing for SS. So, there's not enough for you to make a clear determination there. So you'd need to make some assumptions of fact. So if it's clear that this is a competing business, then maybe they would be put on inquiry. So the indoor management rule would not work in Nirvana's interests. But on the other hand, we've still got the statutory assumptions. So we don't know how Ted has signed the contract. We know that he signed it. The fact that he said to make the loan to SPL quickly, I'm not sure that that would be enough to give rise to an actual suspicion that the company he lacked authority. There's not enough here to say that 127 has been complied with. So go through that, make that point. There's not enough to establish here. If he forged the signature of Jan to try and get the two directors, then we might be able to use 129.5, I think it is. I always get them mixed up, which one's the seal and which one's the no seal. So 129.5 is the document duly executed without a seal. And then move on to saying, okay, well, what if he didn't do it as the company and he's done it as an agent? So then the question is authority. And then we're really talking about 129.2. So third party can assume he's been duly appointed and has authority to exercise the powers and perform the duties customarily exercised or performed by a director of a similar company. So then we'd say, well, look, he's the managing director. Presumably they knew that. Would he have authority to do it? Maybe he would. Of course, just because the company might be bound by the guarantee, that doesn't mean the company has no rights against Ted. So the company would then bring an action for breach of duty against Ted, and might also bring an action for accessorial liability against SPL, either under Rule and Barnes and Addy because Ted is breaching his fiduciary duties, and SPL is knowingly concerned or in knowing receipt of the consequence of that breach, or under the statutory provision, for example, 181, he's not acting in good faith in the best interest of the company, and SPL is involved in a contravention under 181 subsection 2. All right, so could be minor breach of director's duties issues there because we're asked to advise the board of SS. So are they liable? Probably. Depends on the facts, but probably. What could they do about it? Well, maybe they could bring an action against Ted. Okay, and then because of its conservative approach to funding chronic shortage of capital, SS is unable to meet Nirvana's demand, and so Nirvana has begun proceedings to liquidate SPL and might be threatening to do the same to SS. So we might also note, look, there's a potential for insolvent trading risk here. If they've properly entered into the guarantee and it's enforceable and they can't meet it, then the company is quite possibly insolvent right now. So advise the board as to any liability flowing from their management of the company's business. That's an insolvent trading question. But there's not a lot of facts there. We just know cash is a bit tight. They've got this brand new debt. They probably can't pay it. So it's quite possible that Ted and Jan could be liable for insolvent trading. So just go through the basic elements there. So that's kind of the third issue. Is the company liable for the guarantee? What are the directors' liability? And that includes potential breaches of duty for Ted for improperly entering into the guarantee, potential insolvent trading for Ted and Jan. Now we know Jan wishes to dismiss Ted as a director. The simple point to that is unless there's a power in the Constitution, she's not going to be able to do that unless she then convenes a members' meeting, uses her 35% and is able to get at least 2 out of the 3 other equity holders to vote with her to remove Ted from the board. She's not going to be able to remove Ted from the company's share register unless there's already a provision in the Constitution that allows her to do it. And the difficulty here is there isn't, because the question tells us the company relies on the replaceable rules for its Constitution. So she's not going to be able to get rid of Ted from the share register. You might say, well, could she amend adopt a new Constitution that includes a power? The problem there is you're going to run into Gamboto problems. Okay, so there's quite a lot in this question. You really need to plan it out, otherwise you run out of time. Did anyone have any points on that you wanted me to clarify? I don't think this is a terribly difficult question. There's a lot for you to work with. There's kind of 3 or 4 major issues that you need to get through. So you need to be planning it pretty effectively. But otherwise, I think this question's it's not too difficult. Okay, did anyone have any points that you wanted me to go over there? I should just note here that, of course, it doesn't matter. It doesn't matter which way you go on this. So you could say that they're not liable, there's been no breach of duty, that's fine as long as your reasoning is good. Okay, looks like no one's got any questions on that, so that's fine. All right, so I will move on to the next one then. Okay, so question 2. So let's have a look. Again, what's the question actually asking us? Okay. Right, so what's it actually asking us? The new controllers of XYZ seek your advice as to whether any of the former directors acted unlawfully in general or under the Corps Act with respect to the purchase of this business, and would also like to know whether it can recoup any of the losses arising out of the transaction, including from the vendor. Okay, so the new controllers want to know, can XYZ sue the former directors? So just the way the question's worded, I'd be thinking, is this going to be a Regal Hastings type issue? Is this director's duties? Right, so let's have a look. Okay, so Donald is the CEO of Megabucks, proprietary limited company, and Megabucks owns a majority of the shares in XYZ. Now, one thing to look out for here is, okay, so Megabucks, the company, controls the board of XYZ, which is a public company, might be relevant for related parties, so we'll come back to that. But just because XYZ is a subsidiary of Megabucks, that in and of itself doesn't necessarily lead to any kind of shifting of responsibility or anything like that. So we need to be careful. It could give rise to insolvent trading liability for subsidiaries. Let me just check the wording of that. in 588V. So a holding company, yes. One more. Yeah, so the corporate group insolvent trading liability in 588V isn't limited to wholly owned subsidiaries, so that could be relevant here. Given that there's other equity holders, you're not going to be able to use anything like Smith, Stone and Knight. That's not going to work for piercing the corporate veil. What else do we know? So it's a public company, 49% shareholding in XYZ is widely spread among lots of small shareholders. There were 8 directors of XYZ. 4 of those were nominees of Megabucks. All right, now we know that directors have an obligation to act in the interests of their company, even if they're nominated by someone else. And if we look out for the 187 provision in the Constitution, so if a constitution of a subsidiary says that the directors can act in the interests of the subsidiary if they act in the interests of the parent company or holding company, that's in section 187. But that's only for wholly owned subsidiaries, and this is not a wholly owned subsidiary because Megabucks does not own 100%, it only owns 51% of the shares in XYZ. Okay, so there's 8 directors, 4 nominees, and the other directors have no association with Megabucks. So we've got the managing director and 3 other directors, and we've got the replaceable rules. So Megabucks also owns shares in AsConstruct, a small company incorporated in Australia but based in Indonesia, and it wants to be building hotels in Asia. So we know that XYZ is involved in office construction work, and AsConstruct is building hotels in Asia. Donald, who we know is the CEO of Megabucks, is also the chair of AsConstruct. And what you should be thinking here is, this sounds a little bit like PBS and Wheeler. So we've got overlapping directorships, 3-way company, and so I should just note, I haven't written any of these questions. This is a former exam, but the person who wrote this exam, I think, is basing it on roughly on the facts in PBS and Wheeler. Right, and that's where reading cases as part of your prep, doing short summaries of the key case facts, that's where that's really helpful, because you can look through a question and say, oh, this is a 3-way overlapping director situation, just like in PBS. Okay, and then what else happens then? So Donald conceived the idea that Megabucks should sell AsConstruct to XYZ on the basis that the hotel work will complement XYZ's general construction business. Was aware of the recent report that raised concerns about AsConstruct, including poor financial management and high risks. But Donald disregards this document, just calls it a doomsday scenario. Donald phones Oscar, who's the managing director, to discuss the possible sale. And then he tells Oscar, you know, if this sale goes through, Megabucks will pay you a $200,000 success fee. So there's our secret profit, secret commission for Oscar. So one of the things you probably want to do in your planning stage here is set out the different companies, who are the directors on each, who are the shareholders of each, try and make sure you map out the relationships. Otherwise, this kind of complicated fact pattern can tie you up in knots. All right, then, so Oscar could have a problem if he's taking a secret commission to get this deal through. The board of directors meets to consider the proposed acquisition. Anna, Boris, Clarice and Donald all say that they have a conflict because they're nominee directors. They remain while the board discusses the proposal, but they don't make any comments themselves concerning the proposed sale. Right, so this brings up the 194 issue and the 195 issue. 191 rather. So with 191, the duty to declare material personal interests, Now, just because they're nominee directors, that doesn't mean that they'd have a material personal interest in Megabucks. Donald, who's the chief executive, might, because he's the chief executive, but the other directors maybe not. But hey, they're disclosing it. You'd want to be thinking of your Imperial Mercantile Credit and Coleman and your Furs and Tompkins case on the adequacy of disclosure. So just saying that they have a conflict because of their relationship, is that enough? We know that the company adopts a replaceable rule, so that means there's possibly no attenuation clause. There might be no specific written constitution, so they're just relying on the replaceable rules. And the replaceable rule for proprietary companies and voting is 194. So where there's a material personal interest, the director discloses the nature and extent of that interest. That's really the question. They've disclosed that they have an interest. Hey, you know that we're representing Megabucks. What's the nature of their interest? Do they have shares in Megabucks? Does the company maintain a register of director interests, for example? So these are things that we might need to know. Okay, but certainly 194, as long as they've disclosed it, then they can still participate. All right, during the course of the discussion, Oscar, remember Oscar is the chief executive of XYZ. Oscar says, well, this is XYZ's big chance to crack the Asian market. It's a bargain. Okay, how does he know it's a bargain? What's he basing that information on? Is he acting with due care and diligence when he does this? We'd be fools not to take it. Natalie says, I'm not comfortable with this without more information. So at Natalie's, who's one of the non-affiliated other directors of XYZ, so there's no connection with Megabucks. So she's saying, we don't have enough information. You should be thinking duty of care at this stage because they're going to make a decision to acquire this business. And do they really have enough information to know whether this is good value, whether it's something the company should do? We know that Oscar is supporting it. Why is he supporting it? Perhaps he's supporting it because of this potential success fee. And of course, you would know that that's going to give rise to issues under the business judgment rule. So even if he's exercising a business judgment, is he really doing it in good faith, or is he doing it, to get this private benefit? Clearly, he's got a material personal interest in it because of the success fee. There's no way Oscar's going to be able to rely on the business judgment rule. Natalie seems to believe there's not enough information. So query whether the other directors could say that they were properly informed to the extent they reasonably believed to be sufficient. So it's not what a reasonable person would think was sufficient information. It's whether they were properly informed to the extent they reasonably believed that they were. And whether they made a rational decision. That's probably hard to say that this is irrational. Okay, so what else have we got here? And Oscar says, well, if we're all as cautious as you, we'd never do anything. Right, the majority, Oscar, Peregrine, Queenie vote in favour of XYZ. The affiliated directors aren't voting, but they do remain, which they can do under 194 as long as they've disclosed their interests. So query whether they've done that. So maybe talk about cases like Coleman and Furs and Tompkins and Woolworths and Kelly about the nature of disclosure here. Then what else have we got here? Natalie votes against it. That's probably not enough to save Natalie. The board acts as a collective. It doesn't really matter if you voted against it. We know that Peregrine and Queenie have always relied on the judgment of Oscar and Donald, tended to view XYZ's interests as being indistinguishable from those of Megabucks. Are they really acting in the best interests of their company? This brings into play questions about Equity Corp, Charter Bridge test. Now, they're deciding that the interests of Megabucks and XYZ are the same, which means they are bringing consideration. So it's not really a Charter Bridge situation. It's
because in Charter Bridge there was no evidence that the directors considered the interests of their specific company as opposed to the parent company, whereas here there is. It seems like they're thinking, well, XYZ and Megabucks, they're just the same interests. All right, so are they acting in good faith in the best interest of the company? Maybe. Are they acting with due care and diligence? They've always relied on the judgment. That doesn't mean that it's a blind reliance. So it might still be bringing an independent judgment to bear. And if we think about the reliance defence in 189, director who relies on information prepared by an employee of the corporation, in this case Oscar as the managing director, or who relies on another director in relation to matters within the director's authority. So again, relying on Oscar. So this is 189 I'm reading from. Reliance was made in good faith after making an independent assessment of the information or advice, having regard to the director's knowledge, complexity, structure, nature of the corporation, and the reasonableness of the reliance is brought up. The director's reliance is taken to be reasonable unless the contrary is proved. So perhaps Peregrine and Carini could relying on Oscar if the argument is that their reliance on Oscar is unreasonable, given that it's within Oscar's role as managing director. They seem to be doing so in good faith. So there's no evidence that they know that what they're doing here is wrong or is not in the company's best interests. Okay. Oscar, on the other hand, has problems. He can't rely on the business judgment rule. Is he really doing it in good faith? Well, he's not relying on anyone anyway. Be difficult to say he's relying on Donald. So Oscar's got some issues, but maybe Queenie and Peregrine can use the reliance defence and or the business judgment rule. Oscar can't. Donald possibly can't because he's the CEO of Megabucks, and Megabucks is going to get a benefit here. Now, the problem there is we don't know. Well, we know that Donald doesn't own any shares in Megabucks. Just being the CEO, is he getting some other benefit out of it? Just sitting on the board of another company, that's not enough for it to be a material personal interest. After the sale goes through, Megabucks sells its interest to other institutional investors. And then the new board are horrified that the transaction's just been a disaster. Just because the transaction's bad or had a bad outcome, that doesn't mean that it was negligent, doesn't mean it was a breach of director's duties. These things happen. Running a business is risky. All right, so then addressing the question, so any of the former directors, so I'd be going through them separately. Look at Donald and his conduct. Look at Oscar and his conduct. Look at Anna, Boris, Clarice, with respect to not still participating in the meeting, not voting, and then look at Queenie and Peregrine. So set them out as separate headings and then go through the duties. So duty of care. There's nothing here for Anna, Boris and Clarice that says that they're not acting with due care. That's difficult to argue. They're not participating in the vote. So it's difficult to see that they're not exercising due care and diligence. It's not saying that they necessarily have knowledge that As Construct has problems. So it's hard to bring out the PBS and Wheeler. You know, if you actually know problems, do you need to disclose it? Of course, Donald's in a different situation because of his executive role. Well, he's only a non-executive director on XYZ. So it's not the same as, oh no, he's chair of XYZ. So Ray's PBS and Wheeler, so it says up here, he's chief executive of Megabucks and he's chair of XYZ. So as chair of XYZ, he's got access to actual information that's relevant. It's probably not good enough for him to just say, oh, well, I've got an interest, I'm not going to participate in the vote. He certainly hasn't disclosed the nature of the interest. So query whether he's complied with 194. So we've got duty of care issue. applying PBS and Wheeler because of his special position. Is he doing it for an improper purpose? Is he doing it just to benefit Megabucks? You could raise that argument, bring a 181 argument, possibly a 182 argument as well. It's not necessarily a conflict that he's involved in both companies. It doesn't seem like he's necessarily getting any private benefit out of it. Whereas Oscar, on the other hand, is the success fee. So that's an issue. That's a improper private profit. I mean, the fact that Donald knows that he's offering this and he's not disclosing it, is that a problem? Is he concealing it in some way? There's no fiduciary duty to disclose, but by not disclosing it, is he acting improperly for the statutory grounds? So there's quite a lot in this question. You really need to go through and plan it very carefully. You don't have to talk about every single director's duty for every single director. Just focus on the ones that you think are most relevant. But I mean, this will really test both the general law and the statute. Make sure you refer to relevant cases, PBS being the big one, but then with the private success fee, I mean, that's a Furs and Tompkins issues pretty much straight up. And then the disclosure issues with Imperial Mercantile Credit, Coleman, again, Furs and Tompkins, and Woolworths and Kelly in the New South Wales Court of Appeal. All right, and then with respect to the purchase, so this is not a situation where XYZ would be able to rescind the purchase because they didn't know that Megabucks had an interest in it, that the directors had an interest in Megabucks. So it's hard to see how that would work. There doesn't seem to be a situation where the opportunity is only arising because of the fiduciary position. So again, because Donald isn't getting some private benefit out of this, that's difficult to say. But clearly this, I mean, that's the profit rule there for Oscar, as I said. So they might be able to recover that if it's actually been paid. And XYZ would also like to know whether it could recoup any of the losses out of the transaction from any of the parties involved. Well, that's really the duty of care issue. So has it suffered a loss? It suffered a loss because of the breaches of duty. And again, applying PBS and Wheeler here would be really helpful. So would the vote have been any different if they'd fully disclosed everything? Maybe it would have. Maybe it wouldn't have. We know that Peregrine and Queenie tend to rely on Oscar and Donald. So even if they disclosed fully everything in terms of the financial position of AsConstruct, if Oscar and Donald had still told them, look, we know that this information's out there, but we're confident this is a good deal, maybe they still would have followed it. So the causation and damage might be an issue there. Of course, with the statutory duties, applying the civil penalty provision and 1317H for XYZ, because that can include any benefit gained. So again, going after Oscar there. So Oscar could be liable for that under general law and also under statute. Could Megabucks be liable? That's a bit trickier. Is Megabucks knowingly involved in the contravention? Maybe we could raise that argument. The problem is it's only Donald from the board, whereas the nominee directors aren't themselves directors of Megabucks. So it's not as if we can say that Anna, Boris and Clarice they abstained. Yeah, there's no connection between Peregrine and Queenie. Yeah, so it's difficult to say that Megabucks would be knowingly involved in the contravention. Just having Donald's knowledge of what's going on, I'm not sure whether that would be enough. Maybe it would be. Have a look at the Grimaldi case on that, because that talked about Grimaldi's role with Chameleon Mines. Or was it Grimaldi's role with Murchison Metals? And yeah, I think it was Chameleon Mines. So have a look at the Grimaldi case. And it takes us a bit too much into equity Barnes and Addy type territory, which we don't really want to be going down. So I'd just raise it. Being knowingly involved in Megabucks being knowingly involved under 181 sub 2 or 182 or 3 sub 2, and then apply the definition in section 79. So aiding, abetting, assisting, there's a few other elements to that definition. Okay, did anyone have any questions on that? So this is pretty much just a straight director's duties question, but there are multiple duties, and there's both the duty of care and also fiduciary duties and the statutory equivalents. So did anyone have any questions on that? Okay, it doesn't seem like it. So I'll just give you a moment there if you want to type out any questions. Just put a chance to have a drink, save my voice. Right, then we'll move on to question 3. Just empty. Okay, it doesn't look like anyone's got any questions on that, so that's fine. Okay, so we'll move down to question 3. All right, so we've got Dr. Clinton, the world famous scientist. So what's the question actually asking us? Our client is Dr. Clinton, who wants advice as to how he can recover under a particular contract and the joint venture agreement by imposing liability on 2 other companies. And essentially here, a kind of a joint venture vehicle has been set up. It hasn't been fully capitalised. Australis never put any funds into Shelf. Shelf is hopelessly insolvent. Okay. All right, so let's go back and work our way through the question. Okay, so Dr. Clinton has some invention that he's developing. And it's going to offer benefits to smokers. Dr. Clinton meets Mr. Howard at a party. Howard controls Australis tourism company. Howard's managing director of Australis as well. They talk about the invention, decision that Australis and Dr. Clinton form a joint venture, anxious to ensure that Dr. Clinton does not take his invention elsewhere. Howard drafts an agreement on a cocktail napkin. Consideration of $1,000. Clinton agrees not to offer his invention to anyone other than Australis. So essentially this is an option. So we looked at this in contract law. They both sign. Howard, who's the managing director, signs on behalf of Australis. So if you see for and on behalf of, it means they're signing as an agent. They're not signing as the company itself. So don't get into issues about section 127. This is about 126. A company can act through an agent and whether or not Howard had authority to do so. All right, then the next board meeting, Howard proposes to enter into a joint venture. A draft joint venture agreement is prepared. The rest of the board agrees. Because of his standing, the other directors generally bowed to Howard's wishes. So this is bringing in issues around, I think it was Brick and Pipe and the dominant controlling director. However, one of the directors expressed some reservations, became concerned about potential tortious liability. Okay, not quite sure why that's relevant, we'll see. The board resolves that. Oh, okay, right. So to protect the company from liability from this new invention, they're going to set up a wholly owned subsidiary. Howard gets the solicitors to draw up the joint venture agreement and the wholly owned subsidiary. 2 issued $1 shares. So Shelf is the acquisition vehicle that will be through the joint venture. However, the solicitors failed to properly appoint the other directors. Arrange for Howard and another executive director to be appointed directors of Shelf. So Howard is appointed a director of Shelf, but no other directors are appointed because it says the solicitors failed to properly appoint the other directors. And they might still be acting as de facto directors, and failed to appoint Miss Blair as company secretary of Shelf. Failed to appoint. So by saying failed to appoint, I'd read that as, so that means possibly that their details don't appear on the ASIC register as company secretary and directors. And that might be relevant for the operation of 129 sub 2. Joint venture agreement was executed in the solicitor's office. Ms. Blair and Mr. Howard signed. Now, I'd query, how did they sign? So we've got two contracts here. We've got the napkin agreement, which is signed in an agency capacity. And then we've got a more formal contract here. But remember, the napkin agreement is just an option for the $1,000. That's not for the whole joint venture. So we don't need to get into Masters and Cameron territory. I mean, this is not a contract course anyway. But this is just an option that they're agreeing not to offer the opportunity to anyone else for 2 weeks. The 2 weeks so that they can put together the formal contract. All right. Mr. Howard explains to Dr. Clinton that Shelf was for all intents and purposes the same as Australis. Okay, so remember, in the solicitor's office, there's Howard and Blair. Blair is the company secretary of Australis. Howard is the managing director of Australis. And Howard is the sole director of Shelf. So make sure, again, in your planning stage, you're setting out who's who, what the connection is between these different parties. Okay, 1 week later, before production, further research shows that there are problems, basically. All right, so now Dr. Clinton wants to enforce both the cocktail contract and the joint venture agreement. Now, can recover under the cocktail contract, that means, can he get his $1,000? Probably. And you could go through that. I wouldn't spend too much time on it. So Howard is signing on behalf of Australis. He's the managing director. Would a managing director of a company like Australis and a very profitable tourism company, doesn't say how big it is, would a managing director typically be able to enter into an option? Maybe. So you can certainly make that argument that the cocktail agreement was binding. But the key point to remember is it's not that he's signing as a sole director. There are clearly other directors of the company. And then the second contract is the joint venture agreement between Shelf and Dr. Clinton. So it's whether or not Dr. Clinton can enforce that agreement. And maybe he can on the basis that if Howard is the director of Shelf, Ms. Blair might believe she's the company secretary of Shelf, but the solicitors have failed to properly appoint her as company secretary. So she might be signing as company secretary the joint venture agreement. So that could mean that in the solicitor's office, 127 applies because you've got someone who is the director, they're signing as director, and you've got someone who believes they're company secretary and is signing as company secretary. So that could work there, and 127 could apply, and then 129.5 could be used as a third-party assumption. The problem for Clinton, though, is Shelf doesn't have any assets. It's a $2 company, 2 $1 shares. So, yeah, okay, you can enforce the agreement against Shelf. It doesn't have any money. You discover under the joint venture agreement, Clinton was to be paid $500,000 by Shelf on execution of the joint venture agreement. So that means there's a debt if that contract is enforceable. So we look at the enforceability first and then what the consequences are. Howard is alleging neither the cocktail contract nor the joint venture agreement is binding on Australis or Shelf. I think that's a tough argument for both, that the cocktail agreement probably is binding, but that's only $1,000, and it's quite possible that the joint venture agreement is binding on Shelf, but it doesn't have any money. Australis never injected any funds into Shelf, and it's hopelessly insolvent. It has liabilities of more than $1 million under agreements to purchase materials for the manufacture of the filter, as well as its obligations under the joint venture agreement, which would include that. So it's possible that the Shelf is engaging in insolvent trading. Now, the problem is that it's possible that Australis has been supporting Shelf, in which case maybe it wasn't insolvent when it entered into the joint venture agreement, because Shelf was getting the support of Australis. And really, this is going to be a breach of contract claim against Shelf, where Clinton will try to be recovering his $500 grand and then presumably any expectation loss for the failure of the joint venture to go through. So he could bring an action against Shelf, but then the problem is Australis will be cutting off the money. So it might not be insolvent trading. If Australis was supporting Shelf when they entered into the joint venture agreement, so that we could say Shelf at that point was solvent, and now they're making the decision, we're not providing any more money to Shelf, then it would only be future debts that they're incurring that could then be insolvent trading debts. And if you were the lawyers for Shelf, you'd be saying, put the company into liquidation. And one point to note, of course, is that if Clinton has a claim against Shelf for breach of contract, that is not a debt, because it's only a claim for unliquidated damages. Now, this statement up here, think of them as the same. Could we then say that Shelf is acting as the agent for Australis, which, if it were, could then make Australis liable on the contract? So we could try and argue that based on these statements here, in which case Clinton would then bring an action against Australis. But I'm not sure that we could use this information and then say, oh, hang on, Shelf is a subsidiary of Australis, it's undercapitalised, and therefore Smith, Stone and Knight applies. I'm not sure that you'd do that. Because when you look at the questions in Smith, Stone and Knight, the problem is you're not going to be able to satisfy all the questions, because we're not told that Shelf has no independent existence, no employees, no independent bank account, no independent operations. So it's different to Smith, Stone and Knight. Okay, now someone has asked a question here. So Jennifer says, okay, so Jennifer, I'm not sure if you came in late. I did address this at the start. I'm not the coordinator of the JD subject. I can't comment on what the exam would look like. So I'm sorry, I can't answer that. Okay, so just to be clear, so the napkin contract is probably binding because a managing director would probably have authority to enter into that on behalf of Australis, but it's only $1,000. The second contract is the joint venture agreement, quite possibly would be binding on Shelf, but Shelf doesn't have any money. Could it be insolvent trading? Probably not, if Australis was financially supporting Shelf at the time it entered into that. And any debt to Dr. Clinton, if it's for breach of contract, wouldn't be a debt for insolvent trading purposes. It would just be an unliquidated claim for damages. Now, it might be different if the joint venture simply said, well, it says under the joint venture agreement, Clinton was to be paid $500. So maybe that is a debt. It's not he's suing for breach of contract for $500,000. It's that on signing he was due $500,000, in which case it's a debt at that time. But again, my point is, if Australis was supporting Shelf at that time, then it's not insolvent if it's able to pay its debts. And now they're just choosing to breach the contract, and Shelf has no assets. So you can sue them for breaching the contract. You can try and recover the debt from them, but it's probably not insolvent trading if Australis was supporting them. And that includes for corporate group insolvent trading in terms of 588V. Because you still have to prove that they're insolvent, and they're not insolvent if they're getting financial support. All right. So that then brings you to general law agency. But was Shelf acting as agent for Australis? If they were, And if Shelf was acting within the proper scope of its authority, which it seems to be, based on these comments from Howard in his capacity as managing director of Australis. So it's possible that he's saying, no, Shelf is just the agent. Really, you're dealing here is with Australis.
Okay, does anyone have any questions about that? Okay, so that's fine. Okay, so there is a question. So Emma asks, in terms of structure in answering the questions, when it says someone comes to you seeking your advice, does it matter whether you write Dr. Clinton should do, or is it okay to write more indirectly what Dr. Clinton should do? I don't think it matters, Emma. You need to give advice, so you need to advise Dr. Clinton, but whether you do that directly or indirectly, that I don't think that really matters, because we're not asking you to actually write a client advice letter. Dear Dr. Clinton, you've asked me to advise you on X, refer you to prior correspondence, etc., etc. So I don't think that really matters. It's an interesting name. ASIC says, should we answer what about the remedies? Well, the remedy is in terms of what can he recover. And all I'd say is, okay, recovery for breach of contract, recovery of the $1,000 that he's owed under the option agreement on the napkin, recovery of a debt of $500,000. But I just wouldn't go any further than what we've been talking about, which is, okay, yeah, but his napkin agreement is with Australis. He should be able to recover that in full because they have money, but it's only $1,000. The $500,000 is a debt, depending on how it's structured, but that seems to be how this is worded. Was to be paid, so there is a debt in consideration for entering the joint venture. He gets $500,000 up front, but the problem is that's clearly against Shelf, unless we can say that this statement up here makes it an agency contract with Australis, in which case he can claim it against Shelf. So you don't need to go into the ins and outs of damages and what heads of damage he could claim. No, it's just who can he sue, basically. So hopefully that answers your question. Okay, when it says, here's another question from Matthew, Australis never injected any funds into Shelf. Does that not mean that Shelf was never supported by Australis and therefore was trading while insolvent? Yeah, it's a good point, Matthew. Well, you could argue that. It's not an open and shut case though, because maybe they were promising to support it, but then when they decided to cause Shelf to breach the contract, then they pulled their support. So just because you don't actually pay any money in, it doesn't mean that you're not supporting it. And remember, this is a new thing that's happening pretty quickly. It's just 1 week later is when the problems arise. So if there was some sort of guarantee between Australis and Shelf, well, if there was a guarantee, that'd be more problematic because then they definitely have to pay. But if there was some sort of firm commitment, and that's clearly what Howard would be arguing, the problem is going to be that the courts have tended to be fairly sceptical in court hearings about whether a company's solvent, to say, oh, well, we had this rich friend who theoretically could have helped us. You need to have a bit more hard evidence than that. But still the problem's going to be, okay, well, if they were insolvent at the time they entered into the agreement, what's the insolvent trading liability? At max, it would be that. It wouldn't be any kind of expectation or consequential loss that flows from the breach of the contract. But then, as I say, if you can argue agency, then maybe you could go for certainly the $500,000 plus breach of contract against Australis on that basis. Okay, any other questions on this one before we move on? Okay. So I'm just clearing the questions. Okay.
It's fine. All right, so let's move on to the last one then. This one's a bit shorter. Advise Desmond as to his rights and remedies. So we've got a proprietary limited company producing reality TV shows. Company has a constitution which largely adopts irreplaceable rules, but also provides an objects clause. The purpose of the company is about producing high-quality Australian-based reality TV, and specifically says Desmond. All right, so maybe that's going to be a kind of Eli and positive assurance, third-party capacity enforcing the constitution provision type question. Company has two classes of shares, A and B. A-class shares, and then we've got a breakup of the different A-class shareholders. So again, adding up the majorities, who can block a special resolution, who can pass an ordinary resolution, who can pass a special resolution. And then B-class shares only have dividends but no voting rights. So Desmond is an ex-director, so he holds A-class shares and all of the B-class shares, but he's not a current director because he's currently an undischarged bankrupt, but he's still working as a chief executive. And one point to note about this, is only a minor point, but one point to note is that 206 capital B says that a person is disqualified from managing corporations, not just serving on the board, if the person is if they're convicted of an offence, subsection 2. So 206B, subsection 3, a person is disqualified from managing corporations if they're an undischarged bankrupt. So if he's still bankrupt, he's not allowed to be the CEO either. And it's a criminal offence under 206A to take part in the management of corporations when you're disqualified. All right, so Desmond's got that issue. What else do we know? So we know he holds the shares in trust for his family. That's only relevant because if he was an undischarged bankrupt, then any shares that any property that he had beneficially would be vested in the trustee in bankruptcy. Now, you don't need to know that, but that's why I put it in the question that way. Okay, Xavier, Eleanor, and Zena are the formally appointed directors. They've also got 25 A-class shares each. So join those up. We've got our special resolution, 75%. If 2 out of the 3 pass a resolution, they could authorise a range of things through an ordinary resolution. Zena retires, sells the shares to Eleanor, so Eleanor now has 50%. So that would mean that Xavier and Desmond would have to combine in order to defeat an ordinary resolution. And Eleanor and Xavier could combine to pass a special resolution. All right, Eleanor now acts as if she's the CEO. She wants to marginalise Desmond. Okay, so this is sounding a bit like a minority oppression members' remedies type question. With Xavier's approval, so to get the 75%, they appoint 3 new directors to the board. Now it's a proprietary company. So again, the rules on who can appoint directors, who can remove directors. So appointment of directors is under the 201s. So we've got a 201G, the company can appoint a director. 201H, directors may appoint another director. So once Zena sells her shares, it doesn't say, she's retiring from the business. It doesn't say that she stops being a director though, but that's the way I would read it. So if we've got a majority board resolution, Eleanor and Xavier, or if Zena has retired from the board, then the sole remaining directors, Eleanor and Xavier, can certainly appoint new directors. That's not a problem. And that's under 201G, 201H, directors can appoint other directors. All right. And what else then? 12 months later, so after that, the new board decides the company's going to change its strategy. It's not going to be doing reality TV anymore. It's going to change to a cryptocurrency business and will produce YouTube videos on crypto topics. All right, so Desmond's not happy about this. So we can see where this is going. This is advise Desmond. What can he do about it? he's the CEO, but he's not the, he controls 25% of the shares, but what can 25% do? It can't pass an ordinary resolution. He can't appoint directors. He can't be a director because he's an undischarged bankrupt. Desmond feels marginalised. He's not happy with Eleanor's conduct. She then sacks him from his role as CEO, so she passes a board resolution, which she can do. And she makes herself managing director, which again she can do if she controls the board. So that, I mean, it could be oppression, but it's hard to see without more. Okay, Desmond's not happy about it, but that doesn't mean it's oppression. That doesn't mean it's unfairly prejudicial. Now, bear in mind that the effect of the conduct on a member for 232 purposes includes in their capacity or in any other capacity. If we wanted to raise the constitutional point about making reality TV programs under the direction of Desmond, if we wanted to enforce that, of course, we're going to face the Eli and Hickman and Kent problem, that that's a benefit to him in a third-party capacity, not in his capacity as a member. Of course, we know under Section 125, just because the purpose of the company is to make reality TV does not mean that anything the company does that's outside of that is automatically invalid because the ultra vires rule doesn't apply anymore. All right, but issuing the new shares is a different issue. So maybe in your answer you'd say advising Desmond with respect to being sacked as CEO, advising Desmond with respect to the change in the nature of the company's business, and advising Desmond with respect to the issue of the new shares. So issuing the new shares to existing board members. So, of course, Desmond is not a board member, so he doesn't get to participate. These new shares carry 2 votes per share. So one of the things we should know is if you've only got one class of shares and you create a new class, that's automatically a variation of class rights. Of course, here there already was 2 classes. So we're now creating a 3rd class, which has extra voting rights. Board knows that Desmond is bankrupt, so he won't be able to participate, and they can therefore reduce his shareholding through the super voting powers, super voting shares. Then Eleanor tells him the company won't be paying any dividends for the foreseeable future because it wants to invest all of its resources into attracting and retaining top quality staff, i.e. paying the current board. So this really is oppression stuff. Building up a picture of oppressive conduct. Doesn't matter if it's totally legal, which it seems to be. Could we challenge the exercise of the board's management power to issue shares on the basis that it's not really being used to raise money for the company? Now consider the Harlow's nominees case, which talked about other reasons that you might want to issue shares. Is it using it to pursue a commercial opportunity? Is it issuing the shares to reward employees? I mean, maybe in terms of the directors, but so there'd possibly be an argument there about improper exercise of the power to issue shares. Of course, Desmond as a shareholder has the right and equity to challenge an improper share issue. So we could use that. So the residues trading point. Possibility of a derivative suit there for breaches of directors' duties for improperly issuing the shares. Is it really in the company's best interest here, though? So that's going to be a problem. Desmond certainly could have an oppression claim, so we'd use the no paying the dividends, but then just using the funds raised to pay back to the directors. It doesn't seem like the company's really getting any benefit here. So it feels like a bit like a round robin transaction. So it's only the directors who are buying the shares, but then the money that they get from raising the shares, they pay back to themselves as increased pay. So the company's not really getting a benefit out of this. So that might help us in terms of, is this really a proper purpose? Is it in good faith in the best interest of the company? Possibly not, improper purpose. So Desmond could challenge that in his own private capacity. It's a personal right for diluting his shares. He could also bring an oppression claim. Doesn't matter if it's perfectly legal, but in this situation, it's the effect on him in that his voting power is being dramatically reduced and he's not getting any financial benefit because it's refusing to pay dividends. So
issuing the shares, diluting his votes, company not getting any benefit, and paying themselves all the money should show that this is oppression. So Desmond could bring that application. And he's unsure as to whether he should sell his shares, and if so, if he decides to sell them, whether he get a fair price. So that's your 233. The court can assess the price that the majority should buy out the oppressed minority without taking into account the effect of the oppression. So, or rather, taking into account the effect of the oppression. So it's not just the value of it is now with no dividends being paid, it's the value of dividends were being paid. And it was back where he had 25% rather than a dramatically reduced amount. Right, so the mistake here is to treat this just as a director's duties thing. It isn't. It's advising Desmond. He's a member. Advise him in his capacity as a member, but also note this point up here about he's probably not going to be able to enforce the Constitution because of the third-party capacity. Yeah, so mostly oppression, but also personal rights to challenge the improper share issue. You might also say, look, is this actually a just and equitable winding up? Because it's really a failure of substratum. It goes from being a TV company to being a crypto finance company. Should we just divide the assets? I'm not sure. I mean, this is quite different from Tivoli, although that's kind of what I'm getting at here with the dramatic change in business. Maybe, I mean, when you combine what the directors are doing, really trying to squeeze him out, marginalise him, and completely changing the business, maybe a just and equitable winding up, you could argue. Okay, does anyone have any questions on that? And I'll just also throw it open. Are there any other general questions? What are Desmond's personal rights? So minority oppression. He has a personal right to protect the integrity of the share issue. So if shares are being issued for an improper purpose, that's a personal right that he has in equity to protect the integrity of his shares, including the votes. And that was Southern Residues recognise that it's not a derivative right, even though you might say, well, hang on, improperly exercising the power to issue shares is breach of director's duties. Duties are owed to the company, so the companies are proper plaintiff, not members. But in Southern Residues, they recognised, and you could say, I mean, Howard Smith recognised it, Howard Smith and Ampol. There's a number of cases where minority shareholders have challenged the director's issue of shares. So there's a personal right that members have to challenge an improper share issue. Okay, any other questions? With Desmond being sacked as CEO, what should we discuss? I mean, you could maybe include it as part of oppression, but it's hard to see that it is. I mean, if you're not on the board of directors, the board of directors can make a decision to sack you. It's not oppression to sack you, per se. But if you want to include that as part of the, here's why it's oppression, they're doing all these things really to squeeze him out of the company, they need to try that. Really, what he probably wants here is a buyout order. So it's not like the court's going to issue a mandatory injunction that the company has to reinstate his employment. Okay, any other questions? Even if you've got a general question that's outside of these exam questions. Okay. All right, well, if there's no further questions, here we go. Someone's asked a question. All right, so Jasmine, should we focus on topic 3 onwards since the director's duties are heavily discussed in topic 3? So Jasmine, I'm assuming you are a JD student, and as I said at the start, I can't advise you what's in the exam. So I can't say this topic's in, this topic's out. That's a question I'm sorry that you're sad about that, Jasmine. But look, I'm not the coordinator. Yeah, I wrote an exam question, so, and I have seen the exam, but seriously, it was 8 weeks ago. I can't remember what the questions were about. Okay, then Emma asks, okay, yes, so I think Emma, you asked that right at the start. So what would be the main tips for prepping before the exam? Okay, so what I would suggest is So these, Emma, even though you're asking specifically about the LLB exam, these are general tips that I'd say apply equally to the JD. So what I'd say is go through the subject outline. So you've got your different topics. For each one of those topics, come up with about a page of notes, and that should be enough for each topic. So if you're in the JD, when I say a topic, I'm referring to 3.1, 3.2, not the whole of topic 3, which is director's duties, which is huge. So like for director's duties, break it up into the separate duties. So each of those topics, 3.1, 3.2, that should be a separate page of notes. In the LLB course, of course, each class is basically a different topic, so break it up into the 9-10 separate classes. And on that page have what are the most important sections, and then a brief summary of what's in the sections, what are the most important cases, and a brief summary of the material facts in those cases. And then a dot point list of what sort of issues did we look at here? What sort of difficulties came up in the cases? And then, try and anticipate what sort of questions might come up. So the easiest way to do that is to look at, in the LLB, look at the problem questions for each week. In both LLB and the JD, looking at the cases that are listed on the list for that particular class or that particular topic. Look at the fact scenarios, what sort of issues were raised, and just note those down in your notes so that, okay, if we're looking at a conflicts type question, what sort of issues might come up? Try and imagine what sort of questions you might get. And I mean, I've given you some samples here. If we were doing a fundraising question, what sort of issues do we think might come up? If we were doing an insolvent trading question, what sort of issues might come up? Try and anticipate it. Then have a go at former questions. So, I've posted up these ones. If you're in the LLB, if you go through the seminar questions for each class, every one of them has a problem question that you can practice on. Ideally forming study groups, I think, and swap answers. That's usually helpful because it will then show you that the end outcome doesn't really matter. So it's not whether you say there is a breach or there isn't, whether Desmond can get his job back or not, that doesn't matter. It's how you got to that answer. So applying the legislation, applying the cases. So that's in terms of your prep. Now there are questions and answers books that you can also get. And I'll just quickly grab one here. So you should be able to find these in the library. There is a corporations law questions and answers book, looks like that. Yes, I wrote it, but I wrote it years ago. I'm not writing it anymore. I'm not saying you should go and buy it, just saying have a look in the library. Even an older edition, just be mindful of the law though. So that's corporations law questions and answers, LexisNexis Butterworths. And that gives you sample questions, sample answers, kind of tips for problems that might come up in terms of answering certain questions. And then there's this book, which is a much older book. So it's called Mastering Law Studies and Law Exams. And it's by Richard Krever, K-R-E-V-E-R. So this has got just general tips on study, but what's really helpful is the last chapter has sample exam questions for different compulsory legal subjects, including corporate law. And it then has a real answer and then a critique of a real answer, both in terms of what's a average answer for this, what's a better answer for this, and why are they different. So I found that book's quite helpful, Mastering Law Studies and Law Exams. Otherwise, there's lots of textbooks that have sample questions, so have a look in some of the corporate law textbooks, particularly some of the textbooks that are aimed at accounting students. So kind of business law, corporate law sort of things. If you have a look in your subject outline, you might find there's a list of other references. So Lipton and Herzberg. I also, up until recently, was writing a book for accounting students on corporate law. So you can have a look at questions in that. It's just called Australian Corporate Law. Just having a look at former questions wherever you can find them and then trying to write out an answer. Another good approach is to write out an answer, right? Give yourself a bit of space, an hour or so, then come back to it and say, okay, I'm going to argue the exact opposite. just so that you can see where the kind of the ambiguous points in the question are, because that's normally the big issue, the ambiguous point. So the easy things, well, this is obviously satisfied. This is obviously not applicable. That's not the issue. The issue is, wow, I'm not sure whether this is applicable or not. That's really what we want you to focus on. All right, so that's preparing for the exam. Then during the exam, my tips would be plan out your answer. Use that reading time, plan out your answer. You're probably not going to be able to cover everything. So start your answer by saying, I've been asked to advise this party. This is what I'm going to advise them about. So you don't have to give your full answer then, what the conclusion is. Just, this question gives rise to issues about, for example, this question, minority rights and remedies. Then a couple of dot points by saying the following issues are relevant in this question. Okay, a few dot points of the major issues, and then each one of those dot points is a separate heading. So in your answer, when you're going through and writing it out, with those headings that you've got for what you think the main issues are, then leave a bit of space. So when you're doing your answer, I normally suggest try and do about 60 to 70% of your answer. So plan out your time, allocate your time equally for each question because they're all worth the same, and you don't want to run out of time. So plan out your time, whether that's 40 minutes a question or 35 minutes a question, whatever it is. Plan out your time in advance. Stick to that. Try and build in a buffer of a few minutes, maybe 5 minutes or so per question, so that at the end of the exam you can go back and make it better. But go through your answer and try and answer it about 60%, 70%, because what you'll find is where you've got multiple questions, the marginal return you get from that last 20%, that last 15% of marks is hard compared to what you'll get by moving on to another question and then getting it up to a pass or credit level. So you might know everything there is to know about question one, but to actually get full marks for question one, you've basically got to have a flawless answer. So you might write 20 pages, okay? But at some point you're going to run out of time, and because all the questions are worth the same, if you spend an hour and 20 minutes on question one thinking, well, I'm going to nail that and get 20, you might not. You might get 18. Whereas you've then missed a question or you've completely run out of time for a question, and you'll destroy more marks doing that than you'll gain in writing more for one of the questions. So plan out your time allocation, get each answer to about 70%, and then if you planned your time right, you should be able to go back and make it better. Use headings, underline case names, underline sections, use highlighting, whatever you can do to make the important information stand out. That's really helpful for us markers. So basically, we've got the question, we'll have a marking guide. The marking guide will say, okay, here's the key points, here's the key cases, look out for this might be a bit tricky, whatever it is. So there's a list of things that we're looking for in your answer. And if we can pick up your answer and say, oh, look, there's that case that I had to talk about, there's the right section, headings that make it clear what it is you're talking about, that makes the marker's job much easier. But I think that sort of planning helps you as well, because it forces you to focus on what you think is relevant rather than, oh, I think I know what the answer is, and you just start writing and you just end up with, here's everything that I can possibly think about on this topic. And you're not going to get questions like that. They're not going to say, please tell me everything you know about director's duties. The question is going to be focused. Advise this client about this, or advise this client as to their rights and remedies only in this situation. So you're not going to get an opportunity to just write 10 pages, this is what I know about director's duties. So that's in the exam. Okay, so great. Thanks, Emma. Glad that was helpful. Right, does anyone else have any questions? Otherwise, we will draw a close to the exam prep webinar. Okay, so I think we're fine. Okay, so for my students in the JD, if you do want to speak to me before the exam, send me an email. For the LLB students, if you have any questions, post them up on the discussion forum, because I'm monitoring that every day. Okay, I think that's it. There's no more questions. Great, thanks, Jennifer. Thanks, Emma. Okay, so I'll draw a close to that. So this recording will be posted up on Canvas. Good luck with the exam, everyone. If you just go through and practice the questions, focus on what you think the important topics are, and make sure you're using the legislation. Don't just rely on someone else's notes. Make sure you're using the legislation in your prep. That's really the best way for you to prepare. Okay, so I will draw that to a close. So thanks everyone. Good luck with the rest of your exams and have a good break over the summer.